The United States District Court for the Southern District of New York established a fundamental legal precedent in July 2023 by bifurcating the regulatory status of digital asset sales based on the identity of the purchaser. The core of the dispute centered on Section 5 of the Securities Act of 1933, which prohibits the unregistered offer or sale of securities unless a specific exemption applies to the transaction. To determine if the asset was a security, the court applied the Howey Test, requiring an investment of money in a common enterprise with a reasonable expectation of profits derived from the efforts of others. Institutional sales involve $728 million of sales directly to sophisticated entities such as hedge funds and institutional buyers, pursuant to written contracts and specific marketing materials. The court found that institutional buyers provided an investment of money and were part of a common enterprise where their fortunes were tied to the success of the company and the broader ecosystem. Institutional purchasers received promotional materials that emphasized the company efforts to build the ledger, which created a reasonable expectation that the asset value would increase due to managerial expertise. Because these transactions satisfied all four prongs of the Howey Test, the court ruled that the institutional sales constituted the unregistered offer and sale of investment contracts in violation of federal law. Programmatic sales occurred on public digital asset exchanges through the use of trading algorithms, where the identity of the seller was unknown to the buyer, and vice versa. In these programmatic transactions, buyers did not know they were purchasing from the company specifically, because the trades were executed as blind bid and ask transactions in a secondary market environment.
The court ruled that programmatic buyers did not have a reasonable expectation of profit derived from the efforts of others, because they generally did not receive the same promotional materials as institutions. The judge noted that while programmatic buyers may have hoped for profit, that hope was not based on a specific contractual promise or direct communication from the token issuer. Consequently, programmatic sales did not satisfy the legal definition of an investment contract, and therefore did not require registration under the federal securities laws, according to the summary judgment. The third category of transactions included distributions to employees and third parties as compensation or grants, which the court analyzed under a different set of criteria.
These distributions failed the first prong of the Howey Test because the recipients did not provide an investment of money in exchange for the tokens they received from the company. Since there was no investment of money, these distributions were also ruled not to be investment contracts, meaning they did not violate the registration requirements of the Securities Act. The Securities and Exchange Commission attempted to file an interlocutory appeal shortly after the summary judgment, arguing that the court had applied the law incorrectly regarding programmatic sales. Judge Torres denied the motion for an interlocutory appeal in October 2023, stating that the commission failed to meet the heavy burden of showing a controlling question of law. The case also involved charges against top executives Christian Larson and Bradley Garlinghouse for allegedly aiding and abetting the company in its unregistered sales of securities. In a surprising move, the Securities and Exchange Commission voluntarily dismissed the charges against the two individual executives in late 2023, effectively ending that portion of the litigation. The litigation then moved into the remedies phase, where the court determined the appropriate penalty for the institutional sales that were found to be in violation of the law. The Securities and Exchange Commission initially requested nearly $2 billion in disgorgement and civil penalties, arguing that a massive fine was necessary to deter future violations in the industry. The defense argued that any penalty should not exceed $10 million, claiming that there was no evidence of financial harm to investors and no allegations of fraud or recklessness. On August 7, 2024, the court issued its final judgment, ordering the company to pay a civil penalty of $125 million to the government. This fine represented roughly 94% less than what the Securities and Exchange Commission had requested, although it was significantly higher than the $10 million proposed by the defense. In addition to the monetary fine, the court granted a permanent injunction requiring the company to ensure that all future sales comply with federal securities registration requirements. The injunction does not prohibit the company from conducting business, but mandates that any sales to institutional clients must either be registered or fit within a specific legal exemption. The ruling significantly impacted the secondary market by providing a legal basis for exchanges to continue listing the asset without fear of immediate enforcement action regarding programmatic trading. The court also addressed the fair notice defense, noting that the regulatory environment for digital assets was complex, but that this did not excuse the specific violations found in institutional sales. Legal analysts view this case as a landmark because it challenges the previous theory that the digital asset itself is a security rather than the contract under which it is sold. As of early 2026, the case has moved toward the United States Court of Appeals for the Second Circuit, where higher judges will review the district court legal conclusions. The appellate court could affirm the ruling, maintaining the distinction between sales types, or it could reverse the decision and establish a broader or narrower definition for investment contracts. In the summary judgment, the court clarified that an investment of money does not require a cash payment, but can involve any exchange of value or consideration that funds a common enterprise. The court relied on the concept of vertical commonality, finding that the fortunes of institutional investors were directly linked to the success of the company marketing and development efforts. Following the final judgment, the company has modified its sales processes to strictly adhere to the permanent injunction, ensuring all institutional distributions are handled through legal exemptions. The case has accelerated discussions in the United States Congress regarding the need for specific legislation to define digital assets and clarify the jurisdiction of different regulatory agencies. Market participants have largely seen the ruling as a stabilizing force, providing a roadmap for how other digital asset projects might structure their sales to avoid security classification. To summarize, institutional sales were securities, while programmatic sales and other distributions were not under the specific facts presented to the district court. The distinction for programmatic sales is particularly relevant for decentralized finance protocols, where automated market makers execute trades between anonymous participants in a similar fashion to exchanges. The court declined to order disgorgement because the Securities and Exchange Commission failed to show that any institutional investors suffered actual financial losses resulting from the unregistered sales. Ultimately, the litigation underscores that the legal status of a digital asset is not inherent to the token itself, but is determined by the specific economic reality of the transaction. As of May 2026, the legal community awaits the final word from the appellate courts, which will likely define the boundaries of the digital asset market for decades to come.